Lord Advocate.
We welcome back Lord Hope to announce the decision of the court.
Mr. Kapri is an Albanian national. He is alleged to have been responsible for the murder of another Albanian national in London in April 2001, while he was here as an illegal immigrant. The police were unable to locate him after the incident, as he had left London for Glasgow and assumed a false Macedonian identity. They invited the Albanian authorities to prosecute him in that country, as Albania has jurisdiction to prosecute in cases of homicide committed abroad, where the victim and the alleged perpetrator are both Albanian. Mr. Kapri was tried in his absence in Albania. He was convicted and then sentenced to 22 years imprisonment. That decision became final in January 2003, but Mr. Kapri's whereabouts remained unknown to the Albanian authorities. Many years later, in May 2010, the UK police became aware that Mr. Kapri was living in Glasgow. They informed the authorities in Albania, who formally requested his extradition to that country. He was arrested in Glasgow on the 24th of June 2010 and has been in custody ever since. On 20th January 2011, the sheriff decided that there were no bars to extradition and ordered that the case be sent to the Scottish ministers, who decided that they were not prohibited from ordering his extradition. An extradition order was served on the appellant on the 15th of March 2011. Mr. Kapri then appealed and lodged a devolution minute explaining the nature of his challenge under the Scotland Act 1998, which was that his extradition to Albania would breach his convention right to a fair trial. This was because, as he alleged, the Albanian judicial system is systemically corrupt. On the 2nd of February 2010, the appeal court refused to admit certain new evidence which arose under that ground, effectively excluding it from consideration. Following a hearing on another ground, the appeal court dismissed his appeal, but it later gave him permission to appeal to the Supreme Court on the convention right issue only. The Supreme Court unanimously allows Mr. Kapri's appeal. The case will be returned to the appeal court for further consideration of the question whether Mr. Kapri would suffer a flagrant denial of justice if he were to be extradited to Albania. This is a stringent test, and the European Court of Human Rights has observed that until now it has been or would be met only in certain very exceptional circumstances. It will require a breach of the relevant right in the country to which the person is to be extradited, which is so fundamental that it nullifies or destroys the very essence of the right. But none of the cases in which that test has been described was concerned with a complaint of a systemic judicial corruption, as in this case. It is not obvious that the only way it can be met, as it was in those other cases, is by pointing to particular facts or circumstances affecting the case of the particular individual. It is hard to get at the facts, but where allegations of corruption are widespread, they must be taken seriously. When corruption affects the whole system, it may involve simple bribery of judges and court officials, or it may involve interference with the judicial system for political reasons of a much more insidious kind. Unjust convictions may result just to keep the system going and keep prices up. Those who are familiar with the system may know what they need to do to pay to obtain a favorable decision, but be quite unable to come up with what is needed. Those who are not familiar with it will be at an even greater disadvantage. Systemic corruption in a judicial system affects everyone who is subjected to it. No tribunal which operates within it can be relied upon to be independent and impartial. It is impossible to say that any individual who is returned to such a system will receive the right to a fair trial under Article 6 of the Convention. The allegations that Mr. Kapri makes in relation to the corruption of the Albanian judicial system are sufficiently serious for it to be necessary to have a closer look at the evidence on which Mr. Kapri attempted to rely before the appeal court. The Supreme Court is not in a position to determine how systemic or widespread the problem now is. The evidence may not reflect the current position, and further studies are being conducted for the Lord Advocate. So the case will be returned to the appeal court so that it can be provided with up-to-date information and reach a properly informed decision as to whether or not the threshold test is satisfied. The further delay that will result is regrettable, but it is plain that the matters must be properly investigated before a decision is taken as to whether the appellant's extradition should go ahead. For the time being, the appellant must remain in custody. A preliminary issue arose as to whether the question in this appeal raises a devolution issue in terms of the Scotland Act 1998 or a compatibility issue in terms of the Criminal Procedure Scotland Act 1995 as recently amended. The court holds that it raises a devolution issue. The Lord Advocate does not act in his capacity as head of the prosecution service in Scotland when he performs functions under the Extradition Act 2003, so the question in this appeal is not a question that arises in criminal proceedings. And for that reason, it cannot raise a compatibility issue as that expression has been defined in the recent amendments.